Hi, I'm Annie Fitzsimmons. I'm your Washington Realtors Legal Hotline lawyer, and today is the final episode in the video series we entitled Winning the Offer Battle Without Losing the War. And to recap the import of this series, we wanted to leave you with a special reminder as buyer brokers. This is not a warning to your buyers themselves. This is advice to you, buyer brokers. There's an agency law provision affirmed by a recent Washington State Supreme Court requiring every broker in every transaction to advise the broker's client to seek the advice of an expert in areas that exceed the scope of the broker's expertise. And in this absolutely seller-driven, chaotic market where we find ourselves currently, buyers are taking extraordinary risk. And in nearly every transaction, brokers are being forced to work buyers through transactions where brokers are exceeding the scope of their expertise. What am I saying? I'm saying this. When a buyer says to you, gosh, I'm really worried about whether I'm going to be able to park my RV at this home that includes CC&Rs, but I don't want to include a Form 22T, the title review contingency, because I don't want any contingencies in my offer. Buyer is taking a risk, and frankly, buyer is putting you at risk. When a buyer who you believe needs a Form 22T in their offer, the title review contingency, says, I don't want one, buyer brokers, document your file with advice to that buyer to seek guidance from their title review officer and from legal counsel. When a buyer says to you, I have to have a loan, but I don't want to include a financing contingency, buyer brokers, document your file with your advice to that buyer to seek the advice of their loan officer and legal counsel. Buyer brokers, when your buyer says to you, I want to make an offer and not include an inspection contingency, buyer brokers, advise that buyer to seek the advice of a licensed home inspector and legal counsel. And make sure that this advice that you have given to your buyer is given to them in oral conversation and followed up in writing. And the writing can be in the form of an email, and it may say something like this: Buyer, following up on the discussion we had today regarding your choice to write an offer that does not include an inspection contingency. As we discussed, there are numerous inherent risks anytime a buyer purchases real property without first conducting an inspection of the property. I strongly encourage you to seek the advice of a licensed home inspector, here are the names of 3 of them, and legal counsel before you proceed to write an offer without including an inspection contingency. Make sure that however you close this email, you somehow invite a response from buyer. Because what I want you to do is get a reply from the buyer, even if it's a reply about some unrelated topic. Even if the reply is because you've asked a question about how Fido's veterinary appointment went that afternoon. They might not respond to say anything at all about the inspection contingency and might instead say, oh, great news, Fido's in good health. Great. You can now print off their reply along with the email that you sent them to which they replied. You put all of that in your firm's transaction file. Not only have you proven that you checkmarked the box on your agency law duty to advise your client to seek the advice of an expert in areas that exceed the scope of your expertise, you've also checkmarked the Washington Administrative Code requirement that you preserve all material communications in your firm's transaction file. Because in the event of a lawsuit later, I cannot overstate the materiality of this communication with buyer. Having this proof that you advised your buyer to seek the advice of an expert in all of the areas that buyer is going to drag you and our industry through in this marketplace, where buyers are doing absolutely extraordinary things in order to be selected as the seller's buyer. Your documentation of material correspondence proving that you advised your client to seek the expert advice that they need in all of these situations will prove enormously beneficial to you. I hope you never get sued. And honestly, most of you watching this video won't ever be sued. But if all of you take the minimal effort that it will require to have the oral conversation, to follow it in writing, and to preserve that written communication in your firm's transaction file, then the one or two of you who will certainly be sued as a consequence of the craziness of this marketplace, you will have what you need in order to protect yourself in the courtroom. I hope that you take this message to heart, along with all of the other information we've discussed in this series. It is a crazy marketplace. If there are topics that come up for your practice that we haven't already discussed in this series, or maybe that we have discussed in this series, and you want to talk a little bit more about those issues, please send an email to me, legalhotline@warealtor.org. Thank you for being a Washington Realtors member.